Hi, I'm Bob Bianchi. Wow, we got a heck of a trial from 12 to 3. I'll be hosting. I got great guests. We have developments in this Amber Guyger case that are very important. But moreover, right now, prosecutor's closing statement. Let's go to court. Okay, we got a majority of the defense closing statement in there, but it is time to bring in some of our special guests. So Professor Kirk Burkhalter is with me in studio, professor at NY Law, New York Law, 20 years on the NYPD, detective first grade. It's got a tremendous background, and I always love having you in studio. Professor, welcome.
My pleasure.
All right. And we have Scott Major, a trial attorney out there of a prolific nature, Hollywood, Florida. I hear that you have trademark suspenders, and when you're not doing the law, you have spare time is what you concentrate on. He's a TV analyst in many jurisdictions and teaches in multiple law schools. Welcome to the show, Scott.
Hey, thanks for having me, pal.
Okay, and of course we have the infamous, the legendary Gene Rossi, War Room, Eastern District of Virginia, 30-year career, over 100 jury trials, trained over 1,000 prosecutors. My good friend, welcome to the show, Gene.
Good to be on.
Okay, I'm going to ask you guys each one question because we have been debating this at the Law and Crime Network for over a week with all our hosts and our guests, and you can literally go on the Law and Crime Network and find that blog that we did, and you'll see us arguing over this law. Will it be charged? Mistake of law and the Castle Doctrine. I could not see how a judge would preclude that, but I want to go to what I thought was the most strongest point for the defense when they said the state must disprove beyond a reasonable doubt two things: that she did not believe it was her apartment and did not believe that there was an intruder therein. So in other words, Professor, I'll go to you first. You're in studio. If the state can't disprove those two things, it seems pretty consistent with what the jury charges in there. He's saying it's an outright not guilty. Thoughts?
Absolutely. I thought he laid this out very, very well for the jury. So if the state cannot prove either one of those, if the state can't prove that the mistake wasn't reasonable, the jury cannot convict for murder. And I'll go a step further. They can't convict for, more than likely, for any form of manslaughter or criminally negligent homicide either.
I know there's a lot of emotions in this case, a lot of people that have a feeling about what the verdict should be, but the law is what controls. All right, welcome back. So we're in closing statements, but Scott Major, who's been patiently waiting, has to go. I have to get his opinion because he has got some great insights into this case. Scott, it's all yours. Thoughts?
Hey, thanks so much, pal. I mean, I've been watching this trial for a while, and the mistake of fact instruction was devastating to the defense, and it's going to be unfortunate. I think if I were the prosecution, I would wear that giant red doormat around in closing and hold it up in the air as loud as and as forceful as I could, because you have to show that it is absolutely unreasonable for her to believe that she was in her home in order to win this case. I still think you're going to get a manslaughter verdict, but I really think the prosecution needs to do a better job, because the defense has done a great job of looking at the actual instructions and then showing the jury these specific items that make it obvious that it was not reasonable for her to believe that she was in her own home, and then buttress that with the unreasonable nature of her believing that he was going to come at her and hurt her, because it's not supported by the facts. And I think that that would be the strongest argument if the prosecution wants any chance of prevailing in this case.
Scott Major, Hollywood, Florida, an absolutely excellent analysis of what's going on here. I know you got to go. Thank you so much for your time. We'll have you back shortly. Let's go back live to court. All right. The second defense attorney is getting ready to be completed. Gene Rossi, I have to ask you a question. We've obviously been very agitated. I've been looking in our chat room and our second jurors. Was this splitting of the closing statement necessary? Have you even seen it done before? And do you agree with Nelly from our chat room that he's actually helping the prosecution now? That's a quote.
Well, I agree with Nelly that he is not helping the defense. I don't know if he's helping the prosecution. Maybe that's the same thing. Is it necessary? Absolutely not. I had a lot of trials, Bob and Kirk, and I observed a ton of trials, and every time I saw a splitting of an argument, I've seen the prosecution have one attorney do the opening or the opening of the closing and then do the rebuttal. I never liked it, and here's why. That first attorney built up credibility, built up a lot of credibility. He was extremely effective. And then you have this new guy on the block and then the jury basically forgets what the first guy said and is spending their time trying to warm up to the second guy. And the third thing I want to say is the second guy did not focus on the great facts that the first guy did. Therefore, that watered down their argument. So Nellie may be right. It did help the prosecution.
Well, speaking of the prosecution, Gene Rossi, great segue. They are up for a rebuttal to rebut the two defense lawyers you just had gone previously. Let's go back live to court. Wow, okay, we have finally completed. Guys, we got a couple of minutes to talk about this. We got a lot to talk about throughout the whole day. My question, though, kind of comes towards the end. This thing that the prosecutor's doing, and I know I'm going to get our chatters a little, majority of them, great majority of them, and they're a great jury, they feel that this is a guilty verdict. They are very sympathetic to the victim. But as a prosecutor, these comments about the prosecutors are waiting for, our parents are waiting for justice, it's been an indignity so far. Like, is it blaming the defense for that when they're the ones who brought the charges? Unacceptable consequences here in Dallas County. Basically, this is how we do it. Vouching proudly for taking the case. All I can say is, from where I come from, all of those would have been objected to, and if allowed, it would have caused a reversal. Professor.
Well, not only should they be objected to, justice, all these things that he mentioned, community, they mean something different to every single person. In a perfect world, this is an impartial system. Jurors are weighing the facts of the case as they apply to the law, not what they should do to correct the ills of the world.
Right, and Gene, the law says that you are to, in summations, not vouch for your case. You are not a testifying witness. You are to give the facts and the evidence and comment on the facts and the evidence as it relates to the law. And in many instances, respectfully, we'll take a deep dive in this a little bit later, I don't think the law was accurately stated in some instances by the prosecution, respectfully. Thoughts?
Well, I want to talk about him proudly saying, or him saying, I'm very proud to bring the case. If the defense said that the prosecutors are embarrassed to bring this case, there's a concept called the invited error doctrine, where if you attack my integrity and say, Mr. Rossi doesn't believe in this case, in rebuttal, I can get up there and say, I proudly believe in this case. I don't know if that happened. Now, in terms of explaining the law, I got to tell you, I don't have the jury instructions in front of me. I don't get the feeling that he was way outside argument on the instructions, because I can't believe that those two defense attorneys and the judge herself would not have reined him in if he misstated the law.
Well, Professor, to Gene's point, we were talking about that offset when these summations were occurring, and you said that it almost looks like when they're talking about the law, we're looking at two separate trials, and I know you got your notes, and you are the professor. It did, in my opinion, substantially differ from what they were saying there, and I'd never seen a judge give so much latitude in allowing lawyers to speak about the law. That's usually the province of the judge.
It was very interesting because the prosecution basically ignored the Castle Doctrine subdivisions of the justification statute and focused solely on the fact, I think the first prosecutor even mentioned, there was no occupied home because she wasn't in her home. So they just basically dismissed that portion and focused on the other provisions of justification, whereby the defense focused on the Castle Doctrine provisions of the justification statute. So it sounded like you're listening to two different laws.
Yeah, it was quite extraordinary. And listen, well lawyered, we can talk a lot about this case. The Amber Guyger case, guys, is really like one in a million because it's got a lot of nuance and complex law. The jury will be charged shortly by the judge. We got to take a short break, but we'll be back with more law, crime, and this fascinating case. Stay with us.